Mr. Speaker, please recognize the statesman from Davao City, the Honorable Representative Isidro T. Ungab.
Honorable Isidro Ungab, 3rd District, Davao City, is hereby recognized.
Mr. Speaker, before I will ask my question, I would like to ask how many minutes am I allowed to ask for this interpellation?
You're given 3 minutes.
3 minutes only. I understand that's only supposed for the explanation vote, but considering that it's only the time limited or given, so I will just go direct. I have a lot of questions supposedly. Will the sponsor, Madam Sponsor, may I continue?
I will be pleased to respond to the honorable gentleman.
Will the sponsor confirm that no leave was sought and no order was issued allowing either complainant to amend or supplement the consolidated complaint after March 16, 2026?
May we be clarified, Mr. Speaker? Which complaint does the gentleman refer to?
The two complaints, Your Honor. I am supposed to ask questions. There is no House rule and no Supreme Court precedent that allows silent amendment by post-answer evidence. If no leave was sought and no order was issued, then every post-answer factual addition is by definition outside the operative pleading.
Mr. Speaker, if the gentleman is referring to the 2 impeachment complaints, the 3rd impeachment complaint, that is Abalia et al., and the 4th impeachment complaint, that is Cabrera, the Justice Committee did not amend any of those complaints. What the Justice Committee did is to conduct a clarificatory hearing for the purpose of the determination of the existence of probable cause. And it is for the same reason that the Justice Committee exercised its compulsory power, such as the issuance of subpoena ad testificandum and subpoena duces tecum. There is no amendment that happened, Mr. Speaker. Other relevant documents were considered, but the same is for the purpose of responding to the mandate of the determination of whether probable cause exists or otherwise.
If the new evidence merely supports existing allegations, will the sponsor identify the existing allegations in a Zabalia or Cabrera complaint that placed the respondent on notice of A, 1, 313 personal CTRs, second, 1.83 billion in personal inflows, 3, the Madriaga Supplemental's claim of Malacanang armed assault, 4, the names of Kalilong, Lotok, and Anglubin? Are these present in the original verified complaint?
Mr. Speaker, both the Zabalia complaint and the Cabrera complaint mentioned about unexplained wealth and non-disclosure in the SALN. And again, inviting the attention of the members of the House to the test of relevance, test of significance, even if the attachments or the evidence is not attached to the impeachment complaint at the onset, so long as it is relevant, so long as it is germane, so long as it is connected. The rules of impeachment expressly allow the Justice Committee to include the same in the consideration of evidence for the purpose of the determination of probable cause.
I actually disagree, but let me continue, Your Honor. Will the sponsor confirm that the Madriaga Supplemental Affidavit, dated April 11, Annex W of the articles, was executed 26 days after the filing of the respondent's answer?
Nonetheless, Mr. Speaker, following the test of relevance, Mr. Madriaga is alleging the delivery of the confidential fund to the identified locations in his supplemental affidavit. This statement, Mr. Speaker, distinguished colleagues, is of course relevant to the allegation of misuse of confidential fund. And therefore, this should be considered in the determination of probable cause as the same is expressly allowed under paragraph 2, section 7 of the rules of impeachment.
Mr. Speaker, the supplemental affidavit is annexed to the very articles to be transmitted. It is footnoted at footnote 84 of the Article 4 as the evidentiary anchor for assassination, civil obedience, and armed assault at Malacanang. Palas to ensure respondents' assumption of power before 2028. The language does not appear in either the Zabalia or Cabrera complaint. The dates are uncontroverted on the face of the articles themselves. Your Honor, March 16, yung ating respondent ay nag-reply na.
Mr. Speaker, distinguished colleagues, the question being raised by the honorable gentleman is the same question that has been raised for 3 times already. Notwithstanding that the supplemental affidavit was not yet existing prior to the filing of the impeachment complaint, Section 7, Paragraph 2 allow the consideration of the same, considering that the supplemental affidavit is relevant to the allegations of offenses. If I may add, Mr. Speaker, distinguished colleagues, let us be reminded that the threshold that was given to the Justice Committee for the purpose of the determination of probable cause is very minimal, and that is probable cause. When we say probable cause, the Supreme Court pronounced and described the same in the past impeachment processes as merely reasonable justification for us to be able to proceed to trial. With that, Mr. Speaker, distinguished colleagues, we submit that all the evidences not present during the filing, but present during the proceeding are relevant evidence and therefore must be considered as well by the Justice Committee.
My time is expired, but one last comment,
Okay.
Mr. Speaker. The consolidated articles of impeachment, which is supposedly a product of the 2 verified complaints, has been expanded and has included new evidence, and it is only fair and fitting that the respondent should be asked to reply first before that is being brought here in this plenary. That is my point, Mr. Speaker. Where's due process here? If the respondent was not allowed to answer the consolidated articles of impeachment.
Mr. Speaker, distinguished colleagues, as to the question which is being repeatedly raised by the honorable gentleman, let me manifest our position for the last time. Regardless of the fact that the evidence are not yet attached, not yet present, not yet available during the filing of the impeachment complaint, so long as the same is relevant, Paragraph 2, Section 7 of Rules of Impeachment expressly allowed the Justice Committee to include the same in the consideration for the purpose of the determination of probable cause. With regards to his second manifestation, Mr. Speaker, that the respondent Vice President was not given due process, the records will show from day 1 of the justice proceeding, we've been sending notices to the respondent Vice President. As a matter of fact, even after each resource person, for 3 consecutive clarificatory hearings, we were calling the Vice President just to make sure that we're able to cater ample due process because we are consistent to the rules of impeachment, the Constitution, and even the decisions of the Supreme Court.
May I
Representative Ungab, please
be
wrap up.
allowed just one last comment to answer? The argument stated by the lady sponsor conflates 2 doctrinally distinct constitutional requirements. First, 1, what is required? Procedural attendance, the right to be present, to file pleadings, and to participate in proceedings. And second, substantive fair notice, the right to know in advance and with specificity the factual case one is required to meet. The Constitution in Antibay Gutierrez versus House Committee on Justice, and most recently decided Vice President Sara Duterte versus House of Representatives, which was denied with finality, required, and the record will show that the committee provided the first but withheld the second. Whenever post-filing evidence introduced factual predicates absent from the 4 corners of the verified complaint. Thank you, Mr. Speaker.